Okay, numbers are steadying now, so we will get cracking. Good morning, everyone. Thank you so much for joining us this morning. I have a wonderful team assembled to take you through the challenging subject of immigration and its impact on us as hospitality operators and people specialists. For those that might not know who I am, I'm Claire Clark. I'm Director of Hospitality People Services here at Moore Kingston Smith. I joined the business at the start of the year, having had a long career within hospitality in senior leadership people roles in several restaurant businesses. So I now support our hospitality businesses with their people strategy, both from a leadership perspective, but also compliance with the Employment Rights Act, National Minimum Wage, and Trump legislation. Next slide, please, Joseph. So introducing our speakers this morning, we have Mark Barnett, who is Immigration Legal Services Partner, Rebecca Hone, who's Director of Immigration Legal Services, and Joseph, the Solicitor for Immigration Legal Services. So here's the agenda for the morning. Thanks, Joseph. Roughly about an hour of us speaking, so there's plenty, and there'll be plenty of time for questions at the end. There's a Q&A function within the webinar at the bottom of the screen. Please do raise your questions and we will come back to these at the end of the session. We're going to provide hospitality and leisure operators with a clear, practical understanding of UK immigration landscape as it stands in 2026 and how it directly affects workforce planning, recruitment and compliance. The sector continues to face acute labour shortages across front of house, kitchen, housekeeping and management roles, while immigration policy has become significantly more restrictive and enforcement-led. The purpose of this session is not only to explain what the rules are, but to translate complex legal and policy changes into operational insights that decision makers can act on. We will focus on sponsored and non-sponsored work routes, sponsor licence compliance, right to work obligations, and strategic considerations during periods of business such as restructures or acquisitions. Hopefully you'll end at the end of the webinar with a clearer understanding of what's no longer possible, what remains achievable, and where proactive planning can reduce risk and create a competitive advantage in an increasingly constrained labour market. So Mark will take you through the current landscape, what's happened since 2025 and what happens in practice. Rebecca will then take you through alternatives to sponsorship through to enforcement and penalties. And then Joseph will take us through compliance and offer practical suggestions for your businesses. So over to Mark.
Thank you, Claire. So this morning I'm going to look at the current immigration landscape. If I could have the next slide, please, Joseph. So where we are in 2026, we're faced with a background, as you're all probably aware, where the government is under incredible pressure to be tough on immigration, even more than previous governments, particularly for political reasons, and the fact that the recent surge in reform, which they are very eager to combat. So we're looking at not only have the government cut down immigration routes, but they have also imposed increasing restrictions on the sponsor license route, which we're going to have a look at. And they've also been increasing their compliance and enforcement. And just to give you an example of that, in 2025, 3,100 sponsor licenses were revoked. And just to impress upon you the importance of that, where sponsor licenses are revoked, the individual sponsored migrants lose their ability to remain in the UK unless they are able to switch into another sponsored route or different immigration category within 60 days. We're also looking at increased civil penalties on the right to work legislation. So operators such as yourselves need to integrate immigration risk into your strategic strategies. Next slide, please, Joseph. So key changes since 2025. Now, the main change that we have faced is the introduction of the increase in the skill level requirement from 22nd July 2025 from RQF level 6 or above. Previously, after Brexit, Boris Johnson had in fact reduced this RQF level 6 to RQF level 3, which meant that a large number of low-skilled sponsored routes were available. But this increase to RQF level 6, as we'll see later, means that a lot of categories, particularly in the hospitality industry, have now been cut out from being sponsored. We also have now the concept of the eligible role. This was recently introduced and replaces what was previously the genuine vacancy role. So there's 4 key elements to the eligible role. The role must exist at the point the certificate of sponsorship is assigned. The role must require the worker to carry out the duties and responsibilities described on the certificate of sponsorship, including the expected weekly working hours. The job must meet the requirements of the relevant immigration route, which includes complying with the required skill level and salary thresholds under the immigration rules. And finally, which is a key change to the genuine capacity, is that the Home Office must be satisfied that the role is appropriate for the sponsor's organisation, which means it should align with the organisation's business model, business plan and scale, and must remain appropriate throughout the entire period of sponsorship. So you'll see that imposes further obligation on the employer to ensure that it meets those requirements. Next route, please, Joseph. So, as well as the actual requirements, the salary thresholds have increased, and you'll see that the latest minimum salary threshold or general salary threshold as of July 2025 is now 41,700. But bear in mind, though, of course, that with certain job occupation codes, that figure can well be higher. There is still a new entrant threshold, but that's been increased as well and is now 33,400. But that eligibility is restricted to specific groups like graduates and those aged under 26. So, of course, these higher salaries increase your costs, including pension and national insurance, which again affects your bottom line. And you have further recruitment challenges, which have led to you reconsider whether the sponsor license route is the best route for you. And I know that I think Rebecca is going to look at other immigration categories on that route. Next slide, please, Joseph. So what I was saying before about the changes in July 25 mean that certain roles which we're going to look at are no longer available for sponsorship. Now, one possibility is, of course, that employers are looking at retitling roles to try and fit the eligible categories. But the issue with this is that the Home Office are very hot on this, and they are looking closely at job descriptions and other areas to see whether or not, in fact, those retitlement are genuine. And if they're not, then there may be penalties for the employers. Next slide, please, Joseph. So these are the roles which obviously are key, which are now no longer able to be sponsored in a new capacity. So you have hotel and accommodation managers, restaurant and catering managers, and of course chefs, which I know is a key issue for you. Please note, however, that you are still able to sponsor these categories where the individuals already are in those categories sponsored by other sponsors in the UK and were in those categories before July 25 and have been continuously held that permission since then. and provided their subsequent application is made for 4th April 2030. So you are able still to recruit in those categories, but only those individuals who already are holding those job codes with other sponsors. Thank you very much. So I'll now hand back to Claire to introduce the next speaker, who I believe is Rebecca.
Thank you, Mark. So, I mean, really good insight on the changes on the landscape of where we are in 2026. I mean, it's difficult for us, of course, as hospitality leaders when we're operating in that really evolving and challenging labour market. So I suppose, you know, if I'm looking at it from a people point of view, we need to ensure as businesses that our strategies, we're growing from within. So we're promoting internally, and we're having clear progression and skill development pathways. So we're less reliant on those kind of volatile external labour markets. And also that, you know, we've got capable, engaged and productive teams that are delivering consistent guest experience rather than relying on perhaps sponsored workers, which many of the businesses I've worked in the past have relied upon. So Rebecca, you're going to take us through alternatives.
Thanks, Claire. So yes, so far we've focused heavily on the skilled worker route, as historically this has been the cornerstone of overseas recruitment for the sector. Immigration pathways are still available, and just as importantly, how they can be used sensibly rather than as short-term.
Rebecca, you're actually breaking up, so we've completely lost you.
Am I here? Can you hear me?
Yes, perfect.
Okay,
Perfect.
sorry, it just said my Zoom. So this section looks at the practical options that remain, their limitations, and how they fit into a broader workforce strategy. Joseph, could I have the next slide, please? So despite the tightening of the rules, there are still a number of routes that hospitality businesses are using successfully in 2026. One of the most important is the graduate route. This allows international graduates to work in the UK without sponsorship for a limited period. For employers, this can be extremely valuable. It gives you time to assess the individual, meet immediate labor needs, and plan ahead without the upfront cost or complexity of sponsorship. Another option is the Youth Mobility Scheme. This provides temporary labor, often for entry-level or operational roles, but it's time limited and it is restricted by nationality and age. This route is useful to meet immediate recruitment needs, as it is with the graduate route, but it doesn't provide a long-term solution. The real challenge that we see in practice is not understanding that these routes exist, but managing them strategically, tracking these expiry dates, understanding work restrictions, and planning transitions well in advance. Used properly, these routes can relieve pressure. If used reactively, they can store up significant compliance and resourcing problems later on. Joseph, if I could have the next slide, please. So there are some additional routes that often form part of a mixed status workforce in the hospitality sector. So international students that are on a degree level course, for example, are commonly employed, but it's critical to remember that their work is usually limited to 20 hours per week during term time. And as employer, you must retain evidence of their academic term dates. Many of the enforcement penalties that we see arise from misunderstandings of a student's right to work limitations. Also, dependents of sponsored workers usually have the right to work without restriction, although there are some limited exceptions. The UK ancestry route is another available route for individuals with a UK-born grandparent with certain nationalities, including Commonwealth citizens. It's a niche route, but when it applies, it can be very helpful, as there's no limitations on right to work. The key takeaway is that these routes can complement your workforce if managed properly. Next slide, please, Joseph. All of the routes we've discussed sit against the backdrop of a much more demanding sponsor license environment. So it's worth pausing here to look at what a sponsor license actually means in 2026. Next slide, please. So in terms of the sponsor license landscape currently and compliance when holding a sponsor license, the sponsor license system is now firmly enforcement-led. Hospitality is viewed as a higher risk sector due to workforce patterns, turnover, and historic non-compliance issues. We're seeing far more audits, both unannounced and unannounced from the Home Office. And as Mark said, license revocations are significantly up. Most are due not to deliberate wrongdoing, but failures around reporting, record keeping, or concerns about whether sponsored roles are genuine. Smaller or newer businesses face particular challenges, especially at the license application stage. So we would call that the pre-license stage, where checks and requests for detailed financial evidence are now common. The message from the Home Office is clear. Holding a sponsor license is not an administrative exercise. It requires active management, regular internal audits, training for HR and operational staff, and senior oversight. Businesses with a sponsor license should view this as a valuable regulatory permission rather than a formality. And if viewed this way, they are the best ones, the best place to retain their sponsor license. So just circling back to, sorry, Joseph, next slide. Circling back to enforcement and penalties. Again, this is one of the areas that is causing the most concern for hospitality operators. Next slide, please, Joseph. So immigration enforcement activity has increased significantly, and hospitality businesses are frequently targeted. As I said before, this is largely because of diverse workforces, variable hours, and reliance on students and temporary staff. So civil penalties, which are issued for right to work breaches when an employer has not carried out a valid right to work check, and it's found that the employee does not or previously did not have the right to work in the UK. So the fine for these penalties has risen from 45,000, it's risen to 45,000 for a first offence and up to 60,000 for repeat breaches. There's also the reputational impact, which can be just as damaging as the financial cost, as it can be all over the news, and also they keep a public register. Inspections now focus heavily on right to work checks, record keeping, and whether paperwork actually matches what's happening on the ground. Importantly, many penalties arise not from intentional non-compliance, but from administrative errors, missing documents, outdated processes, or misunderstanding around follow-up checks for student working hours. It's important to note that misunderstanding or lack of knowledge around the right to work rules is not a valid excuse, and employers are expected to know the rules as part of employing workers. In summary, awareness, preparation, and consistency are the most effective tools for reducing enforcement risk. So I will now hand back to Claire to cover what Joseph will be talking us through.
Great, thank you, Rebecca. I think it's fair to say that obviously keeping our business compliant isn't a new issue, isn't a new area. Even if you're not a licensed sponsor, it should always be one of your top people compliance areas, and should start being front of mind from even the recruitment stages of an employee's journey. Remember as well, employees' right to work, their status can change throughout their employment. So operators and HR people teams should be using your payroll systems and HRISs to track this. So let's hear from Joseph now about right to work checks in more detail.
Thanks, Claire. Can you all hear me okay?
Yeah.
Right. Okay. Good morning, everyone. Thanks for joining the webinar. I'm going to start off by going through the right to work compliance, which hospitality operators and sponsors and employers in general should be aware of. Before I start with my first slide, sorry, I'll just change it across. There's an update that I want to make you all aware of to do with right to work obligations. So the Home Office introduced some changes to the sponsor guidance relating to right to work checks. Now, the initial position was that sponsors had to establish statutory excuse, which is basically another word for a defence, by carrying out right to work checks on employees and retaining the required evidence. The guidance was then updated to extend this duty to carry out right to work checks and retain evidence for sponsored workers, but they didn't necessarily have to be direct employees. On the 6th of March this year, the guidance was actually updated to extend this duty, the right to work check duty, to all workers not directly employed by the sponsor. There was a bit of confusion about this because there were words thrown around like being directly engaged or what a worker meant. And so then that led to a clarification in the guidance, which was on the 8th of April this year, which basically stated that there's a duty on employers to carry out right to work checks and retain evidence on all workers who are employed or engaged, which includes sponsored workers and other individuals. The guidance itself specifically states under the right to work check section, and I'll read it out quickly for you if that's okay, which basically states as follows. You must check that any worker you wish to sponsor, including a worker who is not your direct employee or any worker you otherwise wish to employ or directly engage, has permission to enter or stay in the UK and can do the work in question before they start working for you. This applies even if the worker is or appears to be a British citizen or other settled worker. If you fail to carry out a right to work check or any necessary follow-up checks, you will be in breach of your sponsor duties and may be liable for civil penalty under illegal working legislation. If you are issued with a civil penalty or otherwise fail to carry out the correct checks, we'll normally revoke your license. So that's touching on what Rebecca dealt with earlier. So the important thing to bear in mind here is that the right to work checks is an obligation on all employers, not just sponsors, to carry out on a worker before that worker starts any services or work for the employer in question. So as it's stated in the guidance, just because someone's a British citizen or a settled worker, you can't take it at face value. You have to carry out the right to work checks, and it has to be done correctly, which involves also retaining the evidence of any checks that have been done on that individual. Now, so moving on to the content matter of the slide, right to work checks. What does that mean for the hospitality sector? So the key risks for hospitality employers, so there's compliance challenges, obviously, with the hospitality sector. Generally, there tends to be a high staff turnover, and there is a use of temporary workers, which increases the right to work checks compliance risks in hospitality. One thing to bear in mind is with right to work checks, you must carry out follow-up right to work checks for those individuals who have temporary permission to stay in the UK, so time limited permission. Obviously, when you carry out a check on a British person or settled worker, with those individuals, they have the right to stay in the UK indefinitely. So you wouldn't need to carry out any right to work checks because it's not time limited. But it's important that you, as an employer, diarise when a person's temporary permission is coming to an end. And what we normally advise is you have sort of notifications, maybe on a 1 month, 2 month and 3 month basis prior to the leave expiring for each individual, so that you're aware of when it's coming up to an end and you can take the appropriate actions. One other thing to bear in mind is there are risks. So some employers, they tend to use third parties to carry out their right to work checks for them. Now, whilst that's not necessarily against the guidance, there are risks involved with third parties, because if you rely on the recruitment agencies or any other service providers to carry out your right to work checks on your behalf, it doesn't transfer liability. So you can't say, well, this was carried out incorrectly by the other person. We gave them the permission to do so and they did it for us. The responsibility lies with you as an employer or a sponsor, if applicable. So Rebecca touched on this before. Another thing to bear in mind is special considerations for students. Now, I know hospitality sector, there are students who work mainly because they can fit around their hours. One thing you need to bear in mind is that they do have restricted hours, as Rebecca touched on. Most of the time, students who are studying at degree level or above are given restricted right to work for 20 hours, usually during term time, and then obviously full time outside. In some cases, students won't be given any right to work if it's degree level or below, or if it's a temporary course. So that means that you should carry out the right to work checks for those students, because the right to work check will actually tell you what the restrictions are on any work conditions, and also whether they have the ability to work in general. Okay, and as you see on the screen there, you need to, and Rebecca mentioned this as well, in addition to the right to work checks for students, you also need to ensure that you retain additional evidence relating to the academic course dates. So the best thing to do in those cases is if they provide you with a letter stating their course dates, it's probably best practice to check the course dates against the course on the website of the institution in question. So, business change and then what it means for immigration. So, restructures, mergers and acquisitions, and immigration strategy. So, the immigration impact of restructures. So, corporate restructures and acquisitions can actually trigger immigration reporting and licensing obligations, and that requires careful management. Usually, when a sponsor is involved in something like a merger, demerger, or takeover, or where there's a similar change, if there's a change of ownership, that usually requires reporting obligations, and it's about 20 working days in most cases. In some instances, depending on what's actually happened, it may actually trigger the need for a new sponsor license application to be made by the new owners of the company in question. And that's important that that's done as well. And sometimes, in most cases, you're usually restricted to making that application within about 20 working days again. So if there are any if you're a sponsor and if there are any changes, it's absolutely crucial that you take advice on what that means for your sponsor license and whether you need to take any action such as a sponsor license, because you have a limited amount of time to do so to ensure compliance. It's important to be diligent. Immigration compliance is crucial during transactions, so to avoid any transfer of any historic breaches or risks. What that essentially means is that if you're a sponsor and you're involved in some kind of change of ownership or merger, and you have sponsored workers coming over to you, you have to ensure that you take the necessary steps to transfer the responsibility of the sponsored workers over to yourselves, if that's what the agreement is. And it's crucial that you also check whether the right to work checks were actually carried out correctly initially for those workers by the previous employer. We call that the seller. And if not, best practice again is to carry out fresh right to work checks to essentially give you that statutory excuse, which I mentioned earlier. It's important to have effective immigration strategy, early identification of sponsored employees, and proactive advisor engagement ensure smooth immigration compliance during those changes. So as I said, it's key to take immigration advice on any changes. More often than not, we've had these situations with some of our existing clients where they've had changes internally within the organisation and restructuring, and they haven't appreciated that they need to take the appropriate steps, which involves making the necessary report, and also in some cases, as I say, applying for a new license. So it has happened. It's likely to happen again. It's important that you engage with good immigration advisors who can tell you about what you need to do. You should also consider protecting your business continuity. So you should integrate any immigration considerations into your transaction planning. That will effectively allow you to maintain your workforce stability and business operations. Okay. All right. So just a few case studies and sector insights from 2025 to 2026. Some of the common immigration challenges that many businesses face is struggling to deal with to sponsor ineligible roles, which Mark touched on earlier, and underestimating the salary requirements in the hospitality sector. Mark's gone over this, but just to add to what he said, there have been a lot of restrictions. So because of the changes in July of 2025, where the RQF level was brought back up to RQF level 6, this has effectively wiped out a lot of lower skilled roles that previously the hospitality sector were able to take advantage of. So that's one challenge that's faced by the hospitality sector, or actually the main challenge that's faced by them. But it's not the end of the world. There are successful compliance strategies that you can take. Successful operators will diversify their recruitment strategies, invest in compliance infrastructure, and align immigration with people strategies, whatever is decided internally. In terms of examples for the hospitality sector, hotel groups, they usually use the graduate routes, which Rebecca touched on. Restaurants sometimes redesign their management, and it's important to note that operators act early to avoid license revocations. So if there is anything that needs to be done, ensure it is done correctly to avoid sort of worst case scenario like a license revocation if a sponsor license is held. It's also key to be proactive with your risk management. Informed and proactive approaches will help you reduce any risks and improve your outcomes amid the challenging immigration environment that we're all facing, but especially in the hospitality sector. Right. In terms of action planning, what would our recommendations look like for you guys? So workforce compliance planning, hospitality operators, we say, should conduct regular audits and review eligibility to ensure compliance with immigration rules. So in terms of audits, it's probably a good idea, again, to engage immigration advisors to carry out a mock audit. That's something we provide to basically check that your processes are up to speed and all the necessary information and documents are held for your sponsored workers or your workers in general in terms of right to work checks. And that's something we have a great deal of experience in. In terms of strategic integration, you should consider integrating your immigration considerations into strategic plans involving growth, restructuring or investments. Obviously, if there's any individuals or roles that you want to apply for, if it's ineligible for sponsorship because of the role itself not being at the required level, then it may be useful to think of alternative routes like Rebecca suggested, and you should involve that in your strategic plans as well to ensure that not only the best candidate is selected for each role, but also that you have a good effective process and a contingency to deal with the challenges. Diversify your recruitment channels to enhance your workforce selection. This is something that you should probably look at as well. Again, because of the challenges that we're facing now, it's a good idea to maybe look at instructing third parties to assist with any recruitment. And in terms of governance and oversight, you should establish clear governance with a senior oversight, and again, access to specialist immigration advice. Because of all the complications, it's good to have immigration advisors who can sort of navigate through the complexities of it all and assist you accordingly. Right, in terms of steps that sponsored license holders specifically should be taking, well, we've set out some of those here. The first thing is to maintain robust HR systems. This is something we almost always advise with any clients we take on who are thinking of getting a sponsor license, unless they obviously have good HR systems in place already. The HR system itself should be good for recording and tracking absences, work location, role changes, and visa expiry dates. The last one is obviously key for the reason I mentioned earlier. You need to ensure that you have on record the visa expiry dates for any sponsored workers, or not just sponsored workers, but anyone who has time-limited permission to stay in the UK. It's absolutely vital that you have that in your records, even though it's obviously the individual's duty to ensure that they have permission to stay in the UK beyond the visa that they may initially have, or when you carried out your right to work checks. You can't obviously employ someone whose permission has expired. So it's important to stay on top of that, and a good HR system will help you do that. Report changes promptly via the SMS. SMS stands for the Sponsorship Management System, which is basically, for those of you who are sponsors, I'm sure you'd be familiar with it. It's basically an online portal that you use to basically do all your reporting and carry out any other duties that you need to, so creating and assigning certificate sponsorship and the like. So I mentioned earlier, when you have any business changes, it's usually required to be reported within 20 working days. So if you are reporting things like ownership, restructures, even address changes, and that's another thing to bear in mind as well. A lot of our clients sometimes change their addresses and they haven't, again, appreciated that they need to inform the Home Office about this, and that there is a very short window in which to do so, 20 working days. So if there are any changes, we usually advise, however small they are, please do check whether you need to report any changes. And if you have immigration advisors, please do use them to check what your obligations are. And in terms of worker changes, this is actually a shorter amount of time. So any change in the worker circumstances has to be reported within 10 working days of the change. So you have even less time to take the necessary action. You should ensure that the role and pay compliance is the same or is consistent throughout the employment. And there was a recent change on this as well, because the Home Office are now coming down heavily at scrutinising whether workers are actually carrying out what they're supposed to be as per the certificate sponsorship that was assigned to them. So you need to ensure that you keep the roles that the individual in question is doing aligned to the actual sponsored SOC code, that's the job code that they were sponsored under, and the skill level. The duties that they perform, as well as the hours worked, must be as stated on the certificate sponsorship, because, and the salary needs to be at the required rate. This is absolutely crucial to bear in mind, because it's just because a certificate sponsorship has been assigned to a worker and they've had their permission, that's not the end of the matter. They need to ensure, or you as an employee need to ensure, that the worker is actually performing what they're supposed to be doing as per their cause. If there are any changes, again, you should check whether that may trigger a report, or B, in some cases, if the role has changed significantly, it may actually require a new cause to be issued with a different subcode, assuming that next subcode is eligible. But also it could trigger, if a new certificate of sponsorship is required, a follow-on immigration application, because that worker would need the a new immigration permission to actually work in that subcode before they're able to do any activities or carry out any duties. You should strengthen your record keeping, retain documents such as payslips, right to work checks, qualifications, evidence of recruitment, or genuine for the required period and ensure that they are readily accessible. So in the past, there was something called the resident labour market test, which is basically, in a nutshell, where you had to advertise for a certain period of time. I believe it was 28 days, and you needed to retain evidence of that as part of your obligations as a sponsor. The resident labour market test isn't around anymore, but you still need to retain evidence of how you identified the candidate, whether that be through some sort of advertisement. The Home Office need to know why this candidate was selected. And basically the reason for that is because they want to ensure that it's not a sham and you're not trying to circumvent the rules to get the person stay in the UK, and it's not a genuine role. Okay, well, that sums up my contribution. So I'll hand back to Claire for questions.
Thank you, Joseph. I mean, it's a complete minefield, and I'm sure, as we all are, once the election nears and rhetoric around immigration will change, and no doubt things will get noisier and tougher for employers. We all have to stay compliant whilst juggling the cost pressures, guest expectations, and developing our great teams. So we've had some great questions. Feel free for those of you watching to add some more questions to the Q&A. So first question that kind of came in for Rebecca, Joseph and Mark. Are there any roles available within hospitality under the sponsored workers route? Because I think, Mark, you put up a slide that had various roles that aren't eligible anymore, but what roles remain for hospitality businesses?
I can take this one, Claire. There are a shortage of occupation in the hospitality sector, but it's mainly, as Mark mentioned, anything that's RQF level 6 or above. So we're talking about positions like directors, finance managers, sort of more senior level roles that can still be sponsored. So it just depends. It has to be a senior level role because, as Mark said, the lower skilled role, without being too offensive, have been taken off. So things like chefs, bakers, pub managers, unfortunately, they're not eligible to be sponsored anymore. So it depends. It's really the senior level roles that can still be sponsored. So if you're looking for someone in your executive board or similar, then that's anything that requires a degree for the role in question is there's a good chance of it being eligible. But other than that, most of the roles, as Mark has shown in his slide, have been taken off, I'm afraid.
Just to add to that, of course, what I mentioned when I was doing my presentation is that you can recruit for those roles from individuals who already are on that route. Yes. So if you can find individuals on that route who are currently sponsored by other sponsors, then you can recruit for them and they can switch across. The other thing, of course, is you can still recruit for those roles within alternative visa categories, which Rebecca mentioned, graduate, students, youth mobility. So you're not you're restricted for those in recruiting for those roles within sponsored workers, but you may be able to recruit them in other categories, or if they're already holding those, they're already in those job codes and have been before July 25.
And it's also important to keep in mind that under the skilled worker route, there are certain categories of
Rebecca's breaking up again. We'll come back to Rebecca after that. So another question has come in. So how does the Home Office treat company size where a linked entity is registered as a branch on the sponsorship license, e.g. whether their turnover should be aggregated into the organisation which holds the sponsorship license for business size classification purposes? So a real long-winded specific question there. So it's treating the company size where a linked entity is registered as a branch on the sponsorship license. Any views on that question?
Claire, can I just clarify? When you mean treat, as in, the question itself, does it mean, do they view it suspiciously or?
Yeah, I mean, it looks like it's whether the business turnover should be aggregated into the organisation which holds the sponsorship licence. So I suppose, does the Home Office look at different sized businesses in order to classify them when they grant the licence, and how are individual branches, or I suppose in hospitality case, individual brands? So should individual brands hold the sponsorship licence, or is it the wider, bigger company? How are the Home Office treating that?
Right. I think what the Home Office look at is whether the company or entity in question has the necessary procedures in place, and they're satisfied that those procedures will be effective. Usually when a sponsor license application is made, an application form is filled out and supporting evidence is submitted in support. So what the Home Office do is they do their own checks. Usually, I mean, not having a website isn't the end of the world, but it does help to show that the company or entity in question is trading and is a legitimate business. In terms of size, sometimes they may look at a smaller company and they may scrutinize it a bit more. But again, if the smaller size company has the appropriate checks, hasn't had any compliance issues in the past, or anything similar, then I don't think the Home Office would have any reason really to either revoke a license if it already has one, or not to grant a license in the first place, because there's a criteria of eligibility and suitability requirements that each sponsor will need to meet, and the Home Office will do their own checks on that to ensure that the company or entity is suitable and eligible. In a way, it's a sort of a yes and no answer. So they may look at a smaller size company with a bit more scrutiny, but it doesn't mean that they'll necessarily not grant the license just because it's not the same size as something that's a well-known brand or a household name.
Yeah.
I hope that answers the question.
I think, Claire, what the questioner may be getting at is that there are different fees when you apply for a license for a small company or a medium or large size company, and also there's different charges for the immigration skills charge which the company needs to pay each year for each sponsored employee. And I think what the questioner is getting at is whether, if they register as a branch on a sponsor license that has already been granted, whether the combined turnover of the two companies counts, or just the individual turnover. But I think it's probably the case that it would be the combined turnover, but we would need to check it, because otherwise the option is that the branch applies for its own sponsor license, not as a branch, in which case there is an advantage to that, although there is an additional cost, of course. But the advantage to that is that the two entities are then ring fenced, so if anything happens to one sponsor license, it doesn't pull down the other entity. So there is advantages to that, although it has cost implications. But I think that's what the question is getting at. And I suspect that the answer is that they will look at the combined turnover when they consider the whether or not the Home Office will consider it as a small or medium or large company, rather than the its own turnover. But I would need to check that further.
Yeah, thank you.
I hope between the two of us, one of us have answered the question, Claire.
Yeah, we've both, again, divulged a load more information, so it's going to be beneficial. Another question, does the UK Home Office offer any bridging or interim visa options for individuals whose current visa, in brackets youth mobility scheme, for example, expires while they are awaiting confirmation of Irish citizenship? So another very kind of specific case here. So
I suspect that the answer is probably not, and the individual needs to make sure that they don't become an overstayer whilst they're waiting for that Irish citizenship to come through. So either they need to make an extension application or switch into another category and file that application before their leave expires, or they need to leave the country or wait to get the Irish citizenship and then possibly enter on the Irish passport.
Okay, so no bridging loans then.
I don't believe so, no.
Yeah. So Joseph, you mentioned the right to work update on the 8th of April. Does this apply to agency workers or purely sponsored workers?
The update that I mentioned was in the sponsor guidance. And so at the moment, it looks like it applies to sponsored workers. And I checked these, so there's a main general guide for employers, the guide to right to work checks. Now, the version that's currently online is June of 2025, so it doesn't look like that's been updated yet. I suspect that there probably will be an update in due course to add that clarification in, but for the time being, it looks like the update I gave was only in the sponsor guidance. What I would say is that the right to work checks should be done. It should be done just to avoid any sort of complication in the future, to be carried out on all workers, regardless of sponsorship or not, even though currently the update is actually in the sponsor guidance.
Yeah, so to be clear, so a number of hospitality businesses, as you know, will take on agency workers and agency staff. So by their definition, they are workers in an employer's place of business, and therefore it would be prudent to just check their right to work when they come and work for you.
Absolutely.
Even though they're employed by the agency.
Absolutely. It'd be best to carry out the right to work checks yourselves as an employer. I'm not sure how it works with recruitment agencies. I'm sure they do their own right to work checks on any individuals before they take them on at their agencies. But as I mentioned before, so an employer can't rely on right to work checks carried out by a third party, which includes things like recruitment agencies. So that's why it's absolutely crucial that the employer themselves, even if they are taking on someone who's basically temporarily engaged by them, it would be good practice to just carry out your own right to work checks, just for that extra peace of mind.
Yeah, great, thank you. So someone's come in with a question. So if I don't hold a sponsorship license, but so this is a similar, but use agencies, do I need to carry out right to work checks? So with regard to agency staff, we've just said yes, but the answer really is, even though you're not a sponsored license holder, you should still do right to work checks on all your employees.
Absolutely. Right to work checks apply regardless of whether or not you hold a sponsor license. So that's a duty on all employers before they take on any workers, regardless of immigration status, regardless of their nationality. A right to work check has to be carried out by every employer on each and every worker before they start work. That's absolutely crucial. So just because you don't have a sponsor license, that doesn't mean that the right to work checks don't apply to you as an employer. It still does apply. And there are different ways of checking depending on the immigration status of the worker in question.
And just to add that any right to work checks that you rely on from an agency, just to have it in as part of your practice to verify that they're correct, because as Joseph said, ultimately it's liable for the civil penalty.
Yeah, so Rebecca, you broke up there, but what I think you said is, even though you might have an agency worker on site, the employer would, as the hospitality business, would be liable for any civil penalty if they were found not to have the correct right to work. Question, so what happens to an individual's right to work when they are a student and then take an approved gap year?
I think that's something we would need to check. I suspect that they are able to work during the gap year, but we need to check that.
Okay, great. Thank you, Mark. Is there a way to pull a report from the SMS on a list of sponsored workers with their details, like locations and SOC etc. Someone's obviously a sponsored license holder because they're saying the system is not made for purpose. So is a way to pull a report of the SOC codes and a list of sponsored workers. Surely that wouldn't be the case because of GDPR. But is there an easy way for an employer to find out the codes, for example?
From my understanding, and I've used the SMS for quite a while, I don't think there's a way to sort of generate an actual list of all your sponsored workers. The way to actually find a sponsored worker's details on your license is usually to use the function view cause and then search for the individual in question. Now, the issue with that is you can only obviously enter one individual's details at a time. So you'd either sort of put in the COS number if you know it, or the individual's last name, date of birth, whatever that may be, and then it'll carry out a search and identify any sort of candidates if they happen to have the last name, any candidates with that last name. But aside from that, I don't think there's any other way to sort of search on a batch basis, if you like, and to sort of generate a list. From my understanding, I don't think that facility is available. And I share the frustrations with the person who asked that question. The SMS is quite outdated. There were talks about the SMS being updated to a new portal, a new type of system. This was a few years ago. The Home Office hasn't done anything since, and I'm afraid it looks like it's staying that way for a while unless we receive any information to the contrary.
Okay, great. So another question on sponsored workers. So if we had a sponsored worker that was a new entrant, and we wanted to change the code, and therefore did a new application, if they transitioned, would they be eligible for the new entrant rate, or would we have to pay the going rate for the new job or code? I can imagine that you would have to pay the going rate for the new job.
So
sorry, Joseph, go on.
No, I was going to say the new entrant. One important thing to bear in mind with the new entrant is that you're only allowed to have combined permission as a new entrant for 4 years. Now, that 4 years includes any time spent by the person in question if they were a graduate, or any previous permission spent as a Tier 2 general migrant, which was the predecessor to the skilled worker route, or even in the skilled worker route, if you've previously had permission under skilled worker route on the new entrant, under the new entrant provisions, okay? So in answer to the question, it depends really on the individual in question, how long they've been in the UK and been sponsored under the new entrant provisions. If it's coming up to the 4 year period, then it doesn't make any sense for them to be paid a salary on the new entry provisions because the permission that will be granted to them won't be for very long at all. If it's a different subcode, then obviously a new certificate of sponsorship will need to be assigned, a new application will need to be made, and it's just a matter of checking when the individual was first granted permission using the new entrant provisions. And if it's coming up to the 4 year period, as I said, you'd have to look at paying them the higher salary for the subcode, assuming that's eligible to be sponsored, whatever that salary is likely to be, which is something that we assess and look at and advise on.
Yeah, I think we would need to look at it on a case basis, looking at the detailed immigration history of the individual, and then assessing whether we think that they would still be able to take advantage of the new entrant provisions.
And the new tables for the occupation codes are very complex, and it's been made that way for a reason, almost to trip you up. So as Mark said, each case should be assessed individually to determine.
Okay, I think this question's already been answered, but it's actually worth reiterating the answer. So you mentioned about sponsors having to carry on checks and retain right to work, even for people who engage with the employer. I just wanted to clarify. So if said people aren't on the employer's payroll, i.e. agency workers, Can I check that the liability for doing the check and retaining right to work info lies with the agency or the umbrella company? No, we've already answered this.
Yeah, we think best practice is to carry out the right to work checks yourselves, and so that you've got them on your records. And also, I think it depends on the terms and conditions that you have with your agency. But the question is, even if the agency is obliged to carry out the right to work checks, does that give the employer any defence? And we think probably not. So the best practice, our advice is best practice, carry out the right to work checks yourselves, particularly in line with the new guidance.
Yeah, great. Well, we don't have any further questions. I think they've all been great questions, actually, and really, really useful discussion afterwards. So unless the three of you have got anything more to say on the subject, I think we can say thanks for everyone for joining us this morning.
Indeed.
We hope you found it invaluable. Joseph, you can share the next slide. I'm going to be a quick bit of advertising for our next webinar, which is coming up on the 4th of June. We're going to discuss the Employment Rights Act, again in some more detail, but also the rights to guaranteed hours and reasonable notice and the planned payments for cancelled shifts. This is all coming into play in 2027. But hopefully by the 4th of June, we'll have a little bit more information on the government consultation. So we'll be able to share that with everybody. And obviously, we've got the latest hospitality sector index as well. So if you scan both those QR codes, you'll get straight to the sites. So thank you, everyone, for joining us today. Thanks to Mark, Rebecca and Joseph.
Thank you, Claire.
And if you've got any questions, then all our details are there, and we'll happily answer anything further that you might have. So thanks very much for joining us, everyone.